by way of overview, we're going to start with some introductory observations just to lay the foundation, set a bit of background before we actually move into the concept of a business transfer itself. And I'm going to deal with the idea of a business transfer almost in terms of a history lesson. That is to say, I'm going to be going back in time to see how both the domestic courts and the European courts have approached the concept of a business transfer over the last few years. We'll then, having done that, move into some of the other intricacies attached to business transfers, change of ownership, temporary cessation in activities, and how that might play a relevant part in whether or not there is a transfer. Some words of wisdom about transfers within the same group of companies, effecting a transfer by a series of transactions, and then finally wrapping up where there is the concept of the transfer of part of an undertaking. The European Court gave guidance for a number of factors to be considered. Firstly, the type of undertaking or business concerned. That, I guess, in modern times is really neither here nor there because of the developments of case law and, of course, the 2006 regulations, recognizing both the concept of a business transfer as well as the concept of a service provision change. But the ECJ in Spikers went on to encourage and indeed direct our employment tribunals, or indeed industrial tribunals as they would have been at that stage, to consider the following. Firstly, whether assets, tangible assets, intangible assets, are transferred between the transferor and the transferee. As a matter of fact, have the employees of the transferor been acquired by the transferee? And then, of course, not only in relation to employees, depending on the nature of the business, whether the customer base of the transferor has been absorbed by the transferee.